Good afternoon, ladies and gentlemen. Firstly, I would like to thank the organizers to organize such a great event once again. I'm from the second time here, and thank you for inviting me. It's always nice to make connections to neighboring states and seeing that our legislative approaches and also the approach of jurisprudence goes more or less in the same way, and that we also more or less speak and deal with same challenges in our countries. When thinking about today's presentation, I chose a risky approach and made a risky move. So I will not present you what was written for the textbook, and I will deviate a little bit of it and speak about those topics that are not mentioned in the book. I've divided my presentation in two parts. Firstly, I would like to briefly mention the recent amendments to the Slovenian Companies Act, but that will be mentioned only briefly. Well, the second part would be even more outside the box, and I will focus on two challenges that are ahead of us and ahead of corporate law in general, and are mainly influenced by the EU regulation. So about the recent amendments to the Slovenian Companies Act, last year there was an act which amended our Companies Act, which from the initial acceptance was, of course, several times already amended, and two EU directives were the main drive force for those changes, namely the digitalization directive and the so-called, as you will see later on, the mobility directive. To just briefly mention the key novelties that were implemented and introduced into our corporate law with the development of the digitalization is firstly the online establishment of companies, which was previously pretty much discussed by our Slovak colleague. And as you can see here now, according to the new legislation, also the articles of association of a joint stock company can now be drawn up in a video transmission as a notarial record in electronic form, and of course it has to be validated by a notary, and also this possibility is now introduced also for the establishment of a LLC. Another step which was made because of the digitalization is the so-called virtual general meeting, which is now allowed, but as you can see, it is allowed in a joint stock company if it's provided for and regulated in the articles of association. There's a key difference to the LLC, where such possibility is given even if shareholders agree with a written statement, so it's not necessary that this solution is already provided in the articles of association. To be honest, that's not our first step in Slovenian corporate law towards the implementing of digitalization tools into our corporate law. Already before that, it was possible to have such a so-called electronic general meeting, which meant that some of the shareholders could participate in an electronic way, which means could cast a vote and so on. But now we are moving even further, so the whole general meeting, everyone can be only virtually present. Well, the basis for that change and amendment of law was already made during the COVID times, where we already had to deviate from our general rules, how a general meeting is conducted. So the task was pretty much easy. We just overwritten that rule in our existing Companies Act. The second change, the second driving force of the recent amendment to the Companies Act was also the Mobility Directive. Before the latest amendment, already all statutory transformations which were conducted within national borders were already regulated in our Companies Act, while only cross-border mergers were regulated in our Act. With the Amendment L, we now regulate also cross-border divisions and also cross-border conversions that are added to our Act. So all the operations of statutory changes are now available also and regulated also for cross-border changes. After a brief mention of the recent changes that were implemented in our law, let me go to the challenges that are ahead of us. I'm focused only on two of them, since there also is a time limit for my presentation. And I've chosen those two challenges that I've been active mainly in the last year. And I'm pretty sure that one of the challenges is also a topic that you for sure came across, and that is the sustainability regulation. In recent years, you all probably have been aware of the endeavors of the EU regulation regarding sustainability. It's already a buzzword as artificial intelligence and so on. And therefore, we've seen and are being present to a lot of new regulation regarding measures how should we sustainable behave, and that is already heavily impacting also corporate law. It's not only a matter anymore of international law, but also that topic is generating a lot of traction in private law and also already in corporate law. What I would like briefly to mention is the so-called corporate sustainability reporting. That's not something new to the company's law, but according to the previous directive, which was many years ago already implemented, it's now extended also to a lot more companies. So previously only bigger companies needed to comply with that regulation, but with the latest directive, which you can see, Corporate Sustainability Reporting Directive, there's been an extension in the scope of the companies which will need to comply. There are also will be new reporting requirements for companies' value chain, also requirements for the integration of sustainability information in the management report, also the assurance and digital tagging of the information reported, and requirements for sanctioning regime for statutory auditors. I'm not showing you this article because I want you to read it now, or that I will even attempt to read it here. I'm only showing you that you get a feeling how that article, which is 19a, is going into detail what kind of reporting will be mandatory, and on which kind of topics regarding sustainability matters will the companies need to report. And if you look those underlines companies that will need to comply. We're moving from large undertakings already also to small and medium-sized undertakings. We are currently in the phase when all the countries will need to implement that new regulation in their national law. There are several dates for the transposition, which vary a little bit from the size of the company when this new reporting needs to be implemented. As you can see, the first deadline that awaits us is the 6th of July. I've checked yesterday on the web page if there are already any countries that implemented that in their regulation, and as you can see, France and Romania are the two that already implemented it. So for other countries, that's still ahead of us. Why is sustainability reporting also gaining traction and coming in and being more and more important from the perspective of greenwashing? That's probably also a term that you came across. There's also a lot going on, and also it's being a directive prepared regarding the greenwashing, and reporting is corporate reporting in something that already can be seen as something where companies try to greenwash their activities or their products by. So therefore, we are also seeing so much regulation and in detail regarding sustainability reporting. There's an estimation that this new reporting regulation will extend quite heavily the companies which will need to comply, and one of the estimations is that from current 11,000 companies within the EU, the new regulation will affect almost 50,000 companies that will need to comply with the new regulation when implemented on the countries. So as you can see, this will be something that also smaller companies would need to take into consideration regarding the costs of compliance with new rules. The second topic, which is in my opinion even more interesting, but it's under the radar. Since sustainability is now the key topic and buzzword, cybersecurity and how it connects to the company law is totally under the radar. According to Allianz Risk Barometer, which was conducted by that insurance company, they made a survey. As you can see, 2,700 respondents, managers, companies, or from all different fields of profession, were asked what they deem, for every year in advance, what they deem as the biggest risk for their business in the next year. What could impact their business the most in the next year? And as you can see, for the second year in a row, they all fear mostly of cyber incidents. Well, cyber security risks and incidents are something that already makes headlines, but I'm not talking about cyber attacks on government homepages and so on. I'm talking about also cyber incidents on private companies. And as you can see, this topic is also across the countries almost, since it's also made in a general survey, what do you deem as the most important? And also they make a statistic from country to country what those companies fear the most. And as you can see, cyber risks is always almost top 3 risks that are important. If you think, or managers of companies think that that cyber security and cyber incidents are something that only could potentially harm other companies and that they are not affected. Well, we already moved from that stage on because we are already facing regulation in that regard. The first step was a directive from 2016, which was then also implemented across the EU countries, but as a first step in sustainability, that only larger companies and more important companies, according to what their business activity is, are affected. We are also seeing in cyber security regulation a step forward as in sustainability regulation, that even by that regulation more and more companies have to comply with. And why am I showing you this as a challenge? Because there was a new directive accepted already, NIS2 directive, which we all will need to implement in our regulation. I also checked the homepage if there's already any information that this directive was in any country implemented, and Croatia was the only one that is stated there that they already implemented that in their regulation. I haven't had the time to check the law that was passed, but I for sure be, especially because in Slovenia there's also a proposal how our legislation will implement that regulation into our national regulation. There are quite a lot. This will bring quite a lot of challenges because the entities which will need to comply will expand. There will no longer be a distinction between the providers of essential services and providers of digital services. It's a rather approach that we have this distinction between essential and important entities, and it depends in which category your company is, which type of obligation, of additional obligations you will need to comply with. Why am I mentioning this as one of the challenges also that is under the radar? Because this new regulation will demand from the management bodies that they will approve cybersecurity risk management measures, oversee its implementation, and can be liable for infringements. So we are facing with a lot of additional duties from the management that they will need to comply, and of course, firstly, they will need to be aware of it. Therefore, I'm speaking about a topic under the radar. Those entities that will need to comply will also need to take appropriate and proportionate technical, operational, and organizational measures. And the regulation goes even further. They will also have to pay attention to the suppliers and the supply chain, how they comply and what kind of measure they have undertaken regarding the cybersecurity measures. So as you can see, quite a lot of additional duties for the management of companies is ahead of us. To conclude, I think I will be in time. Well, to conclude, another open question which will soon, it's not a matter of if, but a matter of time, will arise in our jurisprudence. As you can see, that line from the introduction to the directive, it stated that this directive does not require from the member states to provide civil liability with regard to national persons with responsibilities that they need to comply with the directive for damages suffered by them. And according to that, also our proposal of our act that will implement this directive does not mention the liability of the management if they breach those duties regarding cybersecurity management. Although it's not, as you can see, directly regulated by the directive, and it will not be directly regulated and mentioned, I think it will not be in our act, I still think that those duties which are now prescribed in a really detailed manner what a management has to do regarding cybersecurity could potentially mean they are liable if they breach those duties, but not to a special directive or a special act which will deal with cybersecurity obligations, but according to the general rules how a management needs to comply and how they have to act when they lead the company and make decisions, and therefore only I can refer to our act, our article, which is about diligence and responsibilities, which is used for the liability of the management if they breach their tasks. Usually that article is in focus when they make bad business decisions, and then business judgment rule is used and so on. But as you can see, this article can potentially also be used when the management breaches their new duties according to cybersecurity regulation, and potentially can have an impact on their liability. So I think this is not something that should be overlooked. I've checked the German and Austrian literature. They're already heavily discussing this potential liability, even though that the directive does not directly prescribe that this should be expressively mentioned in the act. But if it's not expressly mentioned, we can still use the general rules on the liability of the management. So, thank you for your attention.